Good morning, everyone. My name is Gary Sheth. I'm a permit writer in Region 9, EPA, and I'm going to be talking about the National Pollutant Discharge Elimination System program today. I've been a permit writer for a long time, over 20 years, and I've probably written over 200 permits during that time. One of the, I guess, interesting things about my background is I also started out in our office when it was both standards and permits, and so I had my initial work was actually doing standards work as well, and so I have a little bit of that background. I wanted to maybe see a show of hands about how many of you are very familiar with NPDES permits? And how many of you probably are not that familiar with NPDES permits? Okay, so for those who are very familiar with the NPDES permits program and might have even attended like the permit writers training, which is put together by EPA headquarters every so often over a period of a week usually. This is going to be very basic because I'm trying to compress what usually is talked about over a week into maybe an hour. That reminds me that actually what I'm going to be doing is if I'm going to go ahead and on our schedule it says that I'm talking about this until 10:20, but I'm going to actually probably go over a little bit, and correspondingly I'm going to not talk that much about mixing zones and compliance schedules, which is this next topic that I was going to cover. There's two other things that I just want to let everybody know, and that is I welcome questions during my presentation, but if they're kind of complex and require more than a couple of line answers, maybe I can answer them after the presentation. So here's the standard disclaimers slide you all see with every presentation. The only thing I wanted to add, and I think maybe it's already also said many times before, but I'll just say it again, is that when I say states, I also, the Clean Water Act also includes tribes and territories under that. And it's kind of important to me to point that out because I'm the NPDES permits liaison for Arizona for our office, but also for all the tribal regions in Region 9, all the tribal lands in Region 9. So here's a big outline or a big picture outline of what I'm going to be covering today. So if you want to sort of tab that in your book or whatever and look at that as we go through the presentation, they'll let you know where we are in my talk here. So, when is an NPDES permit needed? Under 301A, Clean Water Act Section 301A, and the implementing regs 40 CFR 122.1b, all point sources discharging pollutants into waters of the U.S. must obtain a permit from EPA or an authorized state and a tribe or territory. All three aspects of the definition are subject to interpretation and have been shaped by regulations as well as court decisions over time. I believe a lot of you are experts in sort of the water quality side of things, water quality standard side of things, and you instinctively understand the term pollutants and what that might cover. And I believe also that earlier this week there was a presentation. I wasn't here, but I heard that there was a presentation on the waters of the U.S. And it is actually a very contentious area, and probably that presentation brought that out. And so I would refer to questions regarding that to the person who covered that, if you have any. But one thing I want everybody to keep in mind is that the discharge is to surface waters, not groundwaters or aquifers that we're talking about under NPDES permits. And even though, in certain instances, recharge of aquifers might occur through percolation basins that are located on the surface of existing waters of the U.S. and would be covered by an NPDES permit. So I guess the next question is, what is an NPDES permit? It is a permit which is, in my dictionary, is defined as a permission, maybe in written form or a document or a certificate that gives permission to do something. An example, an easy example would be like a driver's license for allowing a person to drive a vehicle in the state. You're definitely able to do it without a driver's license. Lots of people do it, but if you get caught without one, you're in big trouble. And I think that's the same sort of concept with the NPDES permit. The government gives a discharger, an owner of an operator of a point source, the authority to discharge, but with conditions. And if those conditions are not complied with, then just like a driver's license may be revoked if you are in a situation it's like drunk driving or something like that. If you are a willful violator of the conditions in the permit, that would also be grounds for revoking or terminating that permit. And I've heard of a very few instances where that's actually happened. So it's not just hypothetical. One of the other aspects of the definition that we talked about before about when is a permit needed was that it had to be from point source discharges. I think this might have come up many times earlier, that non-point source discharges are not covered under NPDES permits. So how do we define a point source? As you can see from this slide over here, pollutants can enter waters of the US through many different pathways. As we've discussed, typical point sources include discharges from POTWs, publicly owned treatment works, and industrial and commercial facilities, including concentrated animal feeding operations. If you ever visited some of those can be quite interesting. Some others depicted here are industrial, municipal, and construction stormwater and combined sewer overflows, which are often referred to as urban wet weather sources. And of course, we have the instance of direct application of pesticides to the water. Other types of discharges, as I was mentioning earlier, such as agricultural stormwater runoff, are categorized as non-point sources and are not addressed under the NPDES program. But may be addressed under other programs in the Clean Water Act. In the next couple of modules, we will look at the regulatory framework for the NPDES program to see how we issue those permits for these point sources and consider some of the ways that the program has been growing and changing over the years.
I have a question for you. Are you able to comment on how this might apply to reservoir owner-operators and the discharge coming from a reservoir?
If the reservoir itself is not a waters of the U.S., or what kind of situation are you?
They would all be a waters. Well, it's all built within a river, which is waters of the U.S.
Okay, so no, because sometimes there could be, man-made constructed pools or big reservoirs. Okay, so if the discharge from a reservoir is due to some sort of activity?
It's the water they release from the reservoir. So it's like, is it a point source? We don't use NPDES program to regulate that source. I'm just kind of wondering why. It all lives in the world of water rights. So it's my kind of question of, can we look at the water quality of that discharge more
Well,
specifically, and would they qualify
if it is
for
already
an
a waters
NPDES
of the
permit?
U.S., then it wouldn't actually be, a discharge from what's defined as a point source into
There's
a waters of the U.S.
something called the unitary waters rule, which is that if you're not putting the water to, I think, an intervening municipal or other use, industrial, some kind of use, I think that's what you were referencing, and the waters of the U.S. you've connected them and you're just moving pollutants around by moving water, that's not a point source discharge. I think there's a court case on that.
That might be the answer that you're looking for, but I will also get back to you. If you want to talk to me later, we can talk about it and clarify it for you. Yes.
In California, we regulate the confined animal facilities under
Yes.
non-point source.
Oh, okay.
Yeah.
And
In Region 2, anyway. I don't know if it's in San Francisco Bay Region, yeah.
That's interesting. So why? What is the sort of the authority that you use to regulate that as a non-point source?
I think that we are in California looking at the dairy program or as a WDR because we're indicating that they are not discharging to surface waters, in the 25-year time frame is generally how we looked at it in Region 1. And so even though we do have an NPDES CAFO permit available in Region 1, that we haven't elected to use it, and we're instead regulating in a manner that prohibits the discharge to surface water.
Okay, well, that's even better, I suppose, yeah. So I guess the next question that comes up is, now that we know, when do you need an NPDES permit, and what are those sort of the sources for effluents that need to be regulated under an NPDES permit? We need to talk about who is responsible for drafting and issuing these permits, and who will the potential discharger need to deal with to apply for and receive approval for their discharge. The first thing is to determine whether the state is authorized to administer the NPDES program. This authorization is granted by EPA to a state, territory, or tribe if it can demonstrate that it has the legal authority, implementation procedures, and resources necessary to run the program. Regulations in 40 CFR Part 123 address this authorization process, and authorization is no small effort, and it can take many years to get approval. If a state does not have authorization to administer the NPDES program, EPA will be the permitting authority, and where EPA is the permitting authority, the EPA regional office issues the permits, NPDES permits, and takes all enforcement actions and does inspections, monitoring, et cetera. If a state has authority, then it is the permitting authority and performs all the day-to-day permit issuance and oversight activities that I talked about, just previously. Said EPA did that. In this case, EPA acts as in an oversight role, providing review and guidance for the state's program. Under certain circumstances, such as when the EPA objects to a permit or a state fails to enforce the requirements of its permit, of a permit, EPA might determine that the state action is insufficient and may issue its own permit or perform other program functions in the state. If you recall, territories and tribes are also treated as states under the Clean Water Act, and they must also go through a similar approval process to implement the NPDES program if they would like to do so. When we talk about the NPDES program authorization, it sounds pretty straightforward, but that, of course, is not the case. When a state requests authorization to implement the NPDES program, it does not always request and receive authorization for all aspects of the program. By the whole program, I mean, writing NPDES permits, compliance, enforcement. So it might get the authorization in a piece-by-piece basis. So it might have authorization for water quality standards, might have authorization for 401 certification, but it may not still have authorization for actually issuing NPDES permits. Since the program got established, as of July 2018, there are only 4 states that do not have any sort of authorization under the NPDES program, and they are Idaho, Massachusetts, New Hampshire, and New Mexico. But all territories, and except the Virgin Islands, which actually has NPDES authorities in certain aspects, all territories and have no NPDES permitting authority either. And no tribes have yet been issued NPDES permitting authority as of yet. If you want to really get a list of when the states got the authority for the NPDES program, there is a link on EPA's website, but I don't have that right here. But if you just Google state NPDES authorization and EPA, you'll probably get that link, and it'll tell you when that occurred and what aspects of the program were authorized when. So now I'm going to talk about what are the 2 main types of NPDES permits. There are individual permits, and then there are general permits. An individual permit is issued to an individual permittee and requires an application from that individual permittee as well. And it regulates that one individual permittee. A general permit can be before I get into general permits, let me say that an individual permit has the process to issue an individual permit has a lot of administrative requirements, and that usually means that an individual permit takes takes a minimum of 90 days if everything runs extremely smoothly and there are no issues, to a much longer period of time for it to be issued. So it's pretty resource intensive, and both for the applicant as well as for the regulatory agency that's issuing the permits. General permits, on the other hand, can be very resource intensive to develop initially, but since they cover many similar discharges and don't require extensive public notice and comment process once they're in place, they can be very efficient and effective and actually equitable when they have been issued. So the initial process of issuing a general permit can be very complex and similar to an individual permit, but even at a greater level of complexity. But once it's in place, entities that are designated to be covered under that general permit can get coverage by submitting what's called NOIs, or Notice of Intents, and those can be processed very quickly and not take the 90 days to 180 days or even longer that an individual permit might take. Most of you have seen examples of general permits, such as the construction general permit, the MSGP, which is the municipal or the multi-sector, general permit. And those are for stormwater discharges. But EPA has also, and other states have also issued general permits for discharges that are often classified as low threat or fairly clean discharges. So recently in Region 9, where I work, we issued a general permit for low threat discharges in the Navajo Nation, and that permit allows facilities that are mostly either drinking water operators or pipeline construction companies that are hydrostatically testing drinking water pipelines, or new, and this is important to note, new oil and gas pipelines, and they use potable water to hydrostatically test them, and they discharge that. And we were getting a lot of applications for those kind of facilities, and we decided that it would make more sense to have a general permit for that. And the general permit itself has limitations in terms of what the quality of the water has to be, as well as, and this is standard for everybody under the general permit, and also in terms of time, like how long can they discharge, and the amount of water that they can discharge. And it's been fairly successful in the sense that we started to get people applying for NOIs under that permit, and that's helped the dischargers as well as EPA. And I know that states do the same thing. Arizona has they call it a de minimis general permit. I don't know what's the status in the California regional boards, if they have such, yeah. Do all of them have it? Do you? Some do. Which regional board are you?
Region 1 has
Where's
a
Region
low
1?
threat.
Okay.
I think most, but not all, of the California regional water boards have a low threat general permit of some kind.
Okay. And it's, yeah, okay, cool. So next I'm going to talk about the typical NPDES permit components. There's a cover page. There's the effluent limitations, which is sort of the heart of the permit. They could be technology-based or water quality-based, and we'll talk about that a lot more as we go forward. And then there are monitoring and reporting requirements, and there might be special conditions in the permit, as well as the standard conditions that EPA imposes on all permittees, which include provisions such as allowing for reopening the permit, as well as inspections, so on, and operation and maintenance requirements, et cetera. When developing permits, one of the things a permit writer must consider are technology-based and water quality-based effluent limits. The technology-based limits are available to remove pollutants from a discharge, and the limitations are derived and comply with applicable water quality standards for the receiving water. The Clean Water Act also includes requirements for technology-based standards for various categories of point discharges. These technology standards are performance-based and are related to the zero discharge performance goal of the Clean Water Act. The concept that was built into the Clean Water Act was that as the technology improved for a particular industry or group of industries, discharges would move towards that goal of zero discharge for that of pollutants from that group of industries. This concept is reflected in the increasing stringency of performance-based requirements in the Clean Water Act. In practice, that's been not really that quick to be updated. Like, for instance, recently there was an update to the what's called Effluent Limitation Guidelines, which is a technology-based guideline for steam electric generating facilities. The last time that was updated was in the 80s. And now, just recently, like in 2015 or 14, they updated it again. So that's a long period of time between updates, even though the goal is to update it and push the technology towards zero discharge, if possible. I mean, that's pie in the sky, kind of hypothetical, but at least get towards that and use the technology that's out there. If you think about what technology existed back in the 80s versus what exists today for almost everything else, cell phones, whatever, it's amazing what the difference is. And so it's imperative that we use technology-based limits to make sure that dischargers are required to use those technologies to limit their discharges as much as possible. Water quality-based effluent limits, on the other hand, are based on attaining and maintaining the applicable water quality standards for the receiving water body. And they are site-specific rather than being dependent on the type of facility that's being regulated. The relationship between technology-based effluent limitations and water quality-based limitations is straightforward. If technology-based limitations are not adequate to protect water quality, as defined by the water quality standards that apply in the receiving water, then the permit writer must develop water quality-based effluent limits. So, if there's T-bells, doesn't mean that you stop right there. You still, I call the T-bells technology-based effluent limits. That's the acronym. So T-bells mean that's sort of like the floor. They have to meet those. But if even meeting the technology-based effluent limits, the effluent is still causing water quality standards in the water body to not be met, then the permittee might look at imposing water quality-based effluent limits on that same facility or that same permittee. Let me talk a little bit more about the technology-based limits. So the Clean Water Act establishes technology-based performance standards and compliance dates for different type of discharges in different sections of the Act. They're all listed on this slide. I'm not going to go over them individually. What I'd like to point out is the technology-based performance requirements for direct discharge are found at Section 301 and Section 304 of the Clean Water Act. And all the statutory deadlines for those have actually passed. And you'll see how this is important because when we talk about compliance schedules later for, they're not allowed actually. No compliance schedules are allowed for technology-based effluent limits. And the reason is all the statutory compliance deadlines for those have actually have passed. New source performance standards, Section 306 of the Clean Water Act, compliance for new sources is required upon the commencement of the discharge. We will discuss the difference between new source and existing sources later in the model, so let's talk about that.
Can I ask a question?
Sure. Who's this?
This is over here.
Hi,
Hi, Rebecca with the State of California. The secondary treatment standard that's in place for POTWs, is there anything in the works at the federal level to consider updating that to advanced treatment, tertiary treatment?
I am not aware of that. In fact, I didn't mention this, but there's the other side of it, which is there is currently on the regs something called equivalent to secondary, which applies to small systems that, even if they're operated at the ideal way that they're supposed to be operated, and mostly these are systems that are found in, I guess, a lot of tribal areas. They're lagoons, wastewater treatment lagoons. They would actually have what's known as equivalent to secondary, and they're slightly less stringent than the secondary standards. So I know that that exists. Now I'm looking at, you know, if you're asking if EPA is moving towards requiring tertiary standards, I don't know. Manjali, do you have any idea about that? No?
No, but we could probably take the question back to.
Yeah, I think that's a good question to make a note of it. And,
Great.
okay,
Thanks.
sure. Yes?
Is EPA considering how POTWs are now seeing themselves more as water resource recovery facilities? And if so, what impact does that have on permitting?
Yes, for sure. That's a very pertinent question, and it's a hot button kind of issue these days because of drought and climate change, et cetera. And just the fact that water is such a precious resource, especially in the region that I work at, which is Region 9 out here, you know, a lot of arid areas. So yes, that is being considered. One of the things that is required to sort of reuse the water for any purpose, whether it's for, like, you know, irrigation or for direct reuse as a source of potable water. That's like the other extreme. There have to be both regulations in place that put in sort of what the requirements are to do that, and also, you know, the technology has to be in place to make sure that that can be done safely. And EPA is working both. I mean, I know that lots of states. I'm sure California, as well as I know Arizona, because I work with Arizona, they do have reuse standards in their regs, and but they're not for direct reuse to like drinking water or anything like that. It's mostly for reuse for dust suppression or for agricultural use, or irrigation use, or for reuse within a facility, like gray water for like toilets and stuff like that. So that is a big thing, and there is actually, I believe, an effort at EPA Region 9, at least, that I know of, to sort of, you know, gather some of the latest thinking on how this could be implemented. And one of the people that you might want to talk to, if you, I can get him in touch with you, is Dave Smith. He was actually the person who was going to give this presentation initially, and he used to be the manager of the NPDES office in our region, my ex-boss, and now he's not here today. But anyway, he's sort of spearheading that effort. So, yeah, you can definitely talk to him about that. So now we're going to go into sort of the regulatory basis for the NPDES requirements. The NPDES regulations require that these standards be implemented in the NPDES permits both for POTWs and for non-POTWs. And this is sort of the Water Quality Act requirements that you know, underpin the NPDES and NPDES program. So you've talked a lot about Section 101A, 2, and 3, which establish the fishable and swimmable goal and no toxics and toxic amounts policy. Section 303C establishes the framework for water quality standards programs, which all of you are quite familiar with, I'm sure, and requires states to establish water quality standards. Section 304A requires EPA to develop and publish recommended water quality criteria, which are used to establish those water quality standards. And Section 301B 1C requires compliance with effluent limitations necessary to meet water quality standards, and that's actually where the NPDES program comes in. Let's go, next slide. So how do we go from water quality standards to permits? There are 4 basic steps that a permit writer looks at. And the first step is to identify the applicable water quality standards. Step 2 is to characterize the effluent and the receiving water. Step 3 is to determine the need for chemical-specific water quality-based effluent limits. In other words, is there reasonable potential? And so if there is, then chemical-specific water quality-based effluent limits would probably be needed. And then step 4 is to calculate those chemical-specific water quality-based effluent limits. I'm just going to call them limits for make it shorter and easier to refer to. So. Oops, did I go? Okay, this is where I want to go. So step 1, identify applicable water quality standards. So the first step when a new application from a discharger comes in and is determined to be complete in terms of, the basic requirements that are required for application, such as, it has all the necessary components, it's signed by a responsible party, et cetera, is to determine, where the discharge is going to occur and what water quality standards apply to that segment of water, and what are the corresponding designated uses. All of that can be found in the water quality standards for the state where this is occurring, or the regional board. I guess for California there are multiple regional boards. So once the segment and designated use is identified, then you look in the water quality standards to determine all numeric, narrative water quality criteria applicable to that particular water segment. And then also you make sure that you follow any implementation policies associated with the applicable standards. That includes what Manjali just talked about, like the anti-deg issues, or anti-degradation, and that might also include mixing zone policies or compliance schedule policies that I'll cover later on today. The next step is to characterize the effluent and the receiving water. So the first thing to do is to identify the pollutants of concern, or I'm just going to call them pollutants from now on. So the permit writer has, what is a pollutant or a pollutant of concern? It's something that the permit writer has a reason to believe is or may be discharged and could affect or alter the physical, chemical, biological condition of the receiving water. The POCs, pollutants of concerns, are pollutants with an applicable T-bell, so like a technology-based, if there is already a technology-based effluent limit that for a particular pollutant, that is a pollutant of concern. They can also be identified from TMDLs, and they can also be identified through, like if it's a renewal permit, from previous permit monitoring data, and also can be identified just from a category of a discharger that it's expected to be present in the discharge. So water quality standards are pretty key over here. Most states have mixing zone provisions in their water quality standards, and they specify situations in which dilution or mixing zones are allowed, and in some cases when they're not allowed. We'll talk more about that in the next module when I talk about the mixing zones. If mixing zone or dilution is not allowed, then the criteria must be met at the end of pipe. So the discharger is required to meet criteria right at the point of discharge into the receiving water. This is often the case when the water is ephemeral or is effluent dependent. There's no other source of water in the receiving water except the effluent. And so when there's no dilution or mixing, there's no model actually needed to do the next step, which is select an approach to model the effluent and receiving water interaction. There's nothing to model over there. But if there is actually receiving water present, and there is policy that allows for mixing of that of the effluent in the mixing in the receiving water, then we have to select an approach to model how the effluent and the water is going to interact. There are basically two kinds of models that you could look at. A dynamic model, which is very complex and has a lot of moving parts, and as at least in the permits that EPA issues, and I don't know how it is in California, but I know like in Arizona that they don't use dynamic modeling that much. What about, do any of the regional boards use dynamic modeling for development of, or to characterize the effluent and receiving waters? No, not really. Barry, do you know? Okay, the ocean one. So those are probably the ones that are an exception. Okay, but mostly especially for all the inland dischargers, what is usually the case is sort of a steady state model for mixing that assumes critical conditions. And what do we mean by critical conditions? I kind of think of it as sort of like the worst case scenario for the receiving water. So, for example, you would probably look at what's called the 1Q10, or the lowest one-day flow in the last 10 years. Or this is for maybe for acute criteria. For chronic criteria, you might look at a slightly longer period, so it'd be the lowest 7 days of flow in the last 10 years. And all this data is needed to be gathered from other sources. It's not. Terry, you had a question?
So just a comment, in the arid west, the 7Q10 is often 0.
Yeah. So there's no mixing zone.
In the regional boards are basically defined in the regional board basin plans itself. So like I know the Los Angeles Regional Board has no mixing zones.
Uh-huh.
I think in the Bay there's a mixing zone of 10.
Okay.
So they're kind of defined in California.
Yeah, I know that surprisingly Arizona does have a mixing zone policy, and they do have descriptions of what could be sort of critical conditions. There are a few flowing waters in Arizona too, so. Based on these steady state critical conditions, sort of the worst case scenario conditions, then a single receiving water concentration is then developed. So let me go to the next slide. Maybe this is make it a little clearer to see. Oh, we're doing this. Yeah. So this is the slide I want. So the slide looks pretty straightforward. It is actually a pretty complex process to determine expected receiving water concentrations under critical flow conditions. The formulas involve looking at the worst case scenario, as I was talking about, for flow, and the existing ambient loading also of the pollutant in the receiving water, the critical effluent loading as well, an appropriate dilution or mixing model. The key is to keep in mind the components and not get caught up in sort of the details. I want to get the big picture concept across rather than go into the details. And so the big picture is that you identify the pollutant of concern, you determine if mixing or dilution is allowed. If yes, then you use a steady state model to go to the next step. If no, then the criteria apply directly at end of pipe. And then you identify what the critical conditions are for that model, for the steady state model, and then you develop a receiving water concentration. Once you have that, then the question is there reasonable potential? If the projected receiving water concentration exceeds the applicable water quality criteria, then there is a reasonable potential, and the permit writer must establish limits. If the projected receiving water concentration is equal to or less than the applicable water quality criteria, then there is no reasonable potential, and you have not demonstrated a need to establish limits. I know I have a lot of slides to go through, and my time's running short here, so I'm going to kind of go through quickly over here and sort of look at sort of the big picture issues of, or big picture process of how we develop these water quality-based effluent limits. Okay, there it is. As indicated in this slide, waste load allocations can be from TMDLs or calculated on a site-specific basis. What is a waste load allocation? A waste load allocation is the maximum allowable pollutant concentration in the effluent that after accounting for available dilution will meet water quality criteria. This kind of relates back to the discussion that Manjali was talking about with assimilative capacity and anti-deg, but this is from a permitting standpoint. So if there is that available, then that's used to develop the water quality-based limits. I'm going to go quickly through this. And as I said earlier, if there's no water present or there's no assimilative capacity present, then if there's no water present, or if there's no mixing zone allowed in the regs, then the pollutant must meet criteria at the end of pipe. Oh, did I go too fast? So once we have decided that there are T-bells in place, and there is also a need for water quality-based effluent limits, we have to decide what are the actual final limits going to be in the permit. And we compare all of them to each other, and you come up with the ones that is the most stringent limitation for each parameter. And the final effluent limitations in the permit must then meet those limits and also consider anti-degradation and anti-backsliding. I think Manjali talked about anti-degradation and not, is on the 3 tiers in the existing water bodies, and no degradation is allowed to a lower tier unless, it's in tier 2 and there's a cause or the unless clause that you talked about. And under anti-backsliding, limits that have been previously established cannot be made less stringent unless certain factors are met. And those are also in the regs. And such other factors include new information that was not available previously, which would have justified a less stringent limit, or if the limits were established incorrectly due to technical mistakes or mistaken interpretation of the law. I want to just quickly go over sort of the administrative process very briefly. So as I was saying when I was talking about individual permits and general permits, individual permits and the first issuance of a general permit would involve many steps in the administrative process that are used in developing and issuing a permit. You have to document all your permit decisions. That is the administrative record for the permit. You have to coordinate with EPA and state and territorial review of the permits. If the facility is going to be discharging in California and it's being issued by EPA, then California would have to issue a 401 cert for that permit. Also, you need to provide public notice and conduct hearings if appropriate, and respond to all the comments before the final issuance of the permit. I know I'm really zipping through this really fast. Please.
I'm sorry. When do you need a 401 cert for issuance of a permit, an NPDES permit?
You need a 401 cert when the permit is issued. For instance, let's say EPA is issuing a permit, and the permit is being issued in a tribal area, and the tribe has its own water quality standards. Similarly, if EPA is issuing a permit and it's in California, and California has its own water quality standards. So you might find this, like, since California is a delegated state, that's probably not the case for most of your permits. But I'm talking from a different perspective because I work both with tribes and states, and some of the states have not been delegated either, but they have water quality standards that have been adopted by those states. Right.
For California, we're going to have a presentation at the end of the day today from some of our permitting and 401 staff. So hopefully that's covered in their presentation. If not, they're the right people to ask.
I've been told that my time is already up, so I'm going to basically stop over here, and I'm going to put up a couple of links that give more information about NPDES permitting. I really recommend the first link a lot because it's like a treasure trove of NPDES related guidance documents and manuals, and one of the key one being the Permit Writer's Manual itself, which is like the Bible for NPDES permit writers. And if you are, have any questions about permits, you can probably look up either the appendix or the table of contents in that document and figure out, what the answer is. So, thank you.
Can I?
I think we're due for a break now for a short period of time.